questions for you if you can't make them yourself. So these three are going to be in everyone's estate plan, and then we kind of get into other documents if necessary. That all kind of comes out in our initial consultation, and I or whoever you meet with can kind of give you a recommendation on what else you might need. But those three definitely are going to be your bedrock. Okay, so next, what is a will? The will is the document that tells us how to handle your affairs, how to distribute your assets after you're gone. Number one, you'll tell us how to distribute your assets. If you have minor children, you're going to name someone to be their guardian until age 18. You would name a personal representative in your will. Sometimes people call it an executor. We call it a personal representative. So you name someone to be that person that actually handles your estate after you're gone. If you're married, typically it's going to be your spouse. And if it's not your spouse, if your spouse isn't here, you always need to name a backup person. So you would name an adult child or a sister or something. So you always have a backup person, but you would name someone called a personal representative to handle your estate. We would touch on some tax matters in your will. And bottom line is that that will is going to help prevent, in theory, prevents family fighting. We all know what you wanted, and we're going to do what you've asked us to do. Okay. Oh, okay. I'm going to have a little pop quiz. I've got a couple of little questions during my presentation. So I'm sorry for the people that are online. They can't participate as much. But anyway, what percentage of Americans say that everyone should have a will? Anyone want to take a guess? Because I have a little prize if you're right. Okay, yes, sir. He says 38%. Do I hear 39? 39, 30. Yes. 90%. Okay, 39 and 90. Anybody else want to take a 60%? Okay. How many? 95. Okay, he's going all the way. I'm sorry, what'd you say? 42. All right, you guys ready? 72%. So who said 60? Someone said 60. You are our grand prize winner. We have a pair of reading glasses for you. Would you mind coming up? And they say Law Offices of Rose C. Crunkleton. You are welcome. Congratulations. No, not a car. Sorry, not a car. It's not Oprah. Okay. All right. So what happens if you die without a will? And you know that's going to happen. That happens. People die without a will. Well, Maryland has a will for you. We have laws in place, and that's what we're going to look to. So if you die without a will, it's called dying intestate. And I guess in summary, basically your family members are going to inherit. So it's not going to be too bad maybe, but it's not maybe what you would want. Your spouse, if you're married or now new, kind of within the last 2 years, registered domestic partner would receive your entire estate. If you're survived by minor children, however, 50% would go to your spouse and 50% to your minor children. If you're not married, you have no children, your estate is distributed to your parents. If they're not here, then they're to their children, which would be your sibs. If not your siblings, then to their children, which is your nieces and nephews. And we just find the family tree and we fill it in, and that's who gets your estate if you die without a will. Last bottom line though, if we can't locate your family members, or if you really don't have any, your assets go to the county board of ed, not to the state. Many people think that. It just goes to help kids. So it's all right. Yes, ma'am. Oh, okay. Mm-hmm. Well, it also depends on what year that was. But okay, so the question wasn't really a question, it was more of a comment, but okay. Yeah, right. Okay. Okay, so the comment is that her husband, I think I have to repeat that. Is that right, Isabella? Okay. So her husband died without a will, and so his assets were divided between his wife, you, and your adult children. Okay, that's fine. That's how it was. Yeah. So if you have a minor, so they should have gotten a third, right? Is that how it went? That was the old laws. I'm a little, anyway, it's fine. He died without a will. And really, the point is that's what happens. I mean, if you die without a will, then we have a will for you in Maryland. And so that's what we're going to look to and how your or his estate gets divided. Mm-hmm. Well, that was, yeah, 2 years ago. So they've changed it. Yeah. Yeah. It depends on what the legislature does. Sometimes they retroactively put it in effect, and sometimes it's in effect as of October 1, whatever. So she's asking, when do laws take effect? Okay. There, yeah, I know. Well, that's always the problem. So we try to plan as far ahead as we can when we write a will and try to make it meet whatever wishes that you have. So, but just to reiterate, so her husband died with a will, but it was not signed by two witnesses. It does need to be signed by two witnesses. Wills in Maryland have to be witnessed by two people. It does not need to be notarized. But unfortunately, he did it kind of the flip way, which was notarized, but not two witnesses. But the notary would count as one. So there's that. But okay. Okay. So what is probate? Probate is sometimes called estate administration, and this is where the court supervises the distribution of your assets after you're gone. So probate, it's a public process. All record in the file is going to be public record. You can go online and order a copy of someone's will. You can get a copy of whatever assets they owned. It takes a minimum of 6 months to go through probate because we have to allow creditors to come forward. Sometimes it gets tangled and it does take several years, but typically it's going to be pretty quick to go through the probate process. Just a couple, well, 6 months. If no one's fighting, everybody's getting along. I'm sorry, but there's a question in the back. Okay. Okay, so the question is about creditors. So creditors, she's asking how long do you have to wait to open an estate? If you've waited longer than 6 months to open the decedent's estate, can creditors still come forward? No, they cannot. So basically, they have 6 months from date of death to come forward. So if there's an outstanding credit card bill, a medical bill, whatever, you can wait 6 months after date of death. And then the creditors, if they haven't filed a claim against the estate, it gets a little complicated, but if they have not filed a claim against the estate, they really are shut out, basically. So it's kind of unfair in a way, yet that's how it is. We have to have some kind of closure to the estates. We all have to allow it to move on. Yes, sir. I'm sorry, college debt? Okay, so he's asking if his wife's college debt, if he would be liable, if you would be liable for your wife's college debt. If it's in her name only, then it's her debt. And then No, it wouldn't be your responsibility if it's under her name only. So it's her debt goes with the estate. Okay. Okay. Thank you. Yes, we will keep on moving it through then. All right. So the probate process again is the court supervision of the distribution of your estate assets after you die. It can take several months or several years. The person that administers is almost like a clerk of the court, is called a register of wills. Yes, she holds wills for your safekeeping, but she does a lot of other things. But that's just the title. So it's called Register of Wills. The Orphans Court is a 3-member court. In Calvert County, they do not have to be attorneys. They're elected. You've probably seen it on your ballot every 4 years. The Orphans Court determines any kind of disputes if there's any kind of family fighting. And the personal representative is that person we've talked about prior. So that personal representative is the one that files the reports and the accounts, and they're the ones that make sure that the estate is open and then closed with the Register of Wills overseeing everything in the orphans court. Okay. Okay, so requirements of a will, we've kind of already talked about this, but the person that signs the will can be called a testator or a testatrix. Usually we just call it testator. They must have mental capacity to know what they're signing. It's not as much mental capacity that you might need to sign a contract, but they do have to understand that they're giving who they're giving their property to, and that's the purpose of this document. There must be 2 witnesses to the testator's signature, and in Maryland, the will does not need to be notarized. So a will does go through the probate process, and anything inside that estate goes through the probate process. Some people want to avoid probate. They don't want the court overseeing things. They want their loved ones to get their assets immediately, if not sooner, and not have to wait that 6-month period minimum. So there are ways to avoid the probate process. Some are pretty easy and some would require an attorney to get involved. These assets that do not pass under the terms of your will would be assets that are held as husband and wife, maybe your home, for example. Assets held jointly with another person, maybe you and your daughter own a checking account together. As long as there's a joint owner, when the first person dies, the survivor becomes 100% owner, and that's it. No probate. Life insurance proceeds, if they've named a beneficiary, no probate. Retirement benefits, make sure they're up to date, get your beneficiaries on there, no probate. You can name payable on death for bank accounts. Those are, shorthand would be called beneficiaries, payable on death, or transfer on death beneficiaries. Those are for more like your brokerage accounts, like Merrill Lynch. So TOD or POD, those 2 designations work the same way. They're beneficiaries and they avoid the probate process. Many people don't realize you can also add a beneficiary to your car. So you go on the MVA website, it's $20, and you can name a beneficiary on your car. And then the grand poobah is the trust, the revocable living trust. Any assets that we transfer into a revocable living trust will avoid the probate process. So assets inside of a trust are going to avoid probate. But I do want to caution everybody, don't run and go your beneficiaries up to date. Please talk to an attorney first and just see the whole estate plan. Let's look at the whole picture before we go and do any kind of beneficiary designations and joint ownership and other things that might not be in your best interest. But just kind of keep those in your back pocket. Those are ways to avoid probate. Okay, minor children. If you have minor children, we would want to name a guardian in your will to raise your minor children until age 18. You would want to name a backup person. This is probably the hardest thing for the young couples that come in my office. Not, who's going to pull the plug, if you want to call it that. No, it's always, who's going to raise it? Not her. She's not raising our children, the fighting right in front of me. But that's going to be a hard decision for many parents. And not only one person, but you've got to name a backup person as well. In your will, we would actually set up a trust inside the will that would pop up in case your minor children are under a certain age. You can pick any age you want for the trust to dissolve, but basically we'll have this, their inheritance would be overseen by a trustee until they attain the age of 18 or 25 or whatever you want. Most people don't choose 18 because we all remember what we were like at 18, and that's not where you want your money to go. So, maybe after college at age 22, there's different thinking of how old you think people might be responsible. But the idea is that you kind of control when those minor children get the assets, and also who would be their trustee, because you might like your daughter but not want her husband, So you can name who would be the trustee of those assets on behalf of your minor children. I said daughter, I should have said niece or something. Okay. Anyway, with step families, that can get a little tricky, the blended families. So here's an example of what could happen. Husband and wife have 3 adult children, and then the husband and wife divorce. The husband remarries, and he adds his new wife's name to all his assets. Then he dies, and you just saw on one of the previous slides, new wife is going to get everything. If her name is on those assets, she now becomes the sole owner of all those assets that were titled as husband and wife. And now the husband has accidentally disinherited his 3 adult children. So there's things we can do to avoid that, but that's just kind of the thinking you gotta work through on second marriages and stepchildren. Some other special example circumstances, maybe you have a small business, an LLC. We would probably want to know who's going to run that LLC if you're gone. If it's a very successful LLC, you might want it to keep going. So we want to put that kind of thing in writing. If you have special needs children, whether they're minors or adults, if they're on Medicaid or SSI, they're going to need to have their inheritance put inside a special needs trust. Otherwise, they're going to be disqualified from those public programs, assuming those programs are still around the way things are going these days. Parents of children under other kinds of disability would also create a trust. Maybe you have a child who's, I'm sorry, but if they're abusing, if they're substance abuse of some sort, maybe you don't want them to have the cash, but you want them to have the benefit of it, $500 a month, something like that. So, you can use trust. Trusts are beautiful instruments that can really help create benevolence and help make you happy and at peace. You can rest in peace. Unmarried couples, this is rather new. You can register as a domestic partner. As such, you would be exempt. Domestic partners that aren't married, if you register at the courthouse, you would be exempt if someone died from the inheritance tax, and you'll get I call it a $10,000 signing bonus. You would get that. So it's rather new, and that's something too to think about if you are residing with someone else and you want to register as a domestic partner. If you break up, you have to go back to the courthouse and sign a different paper, but it's not a divorce. It's not the big thing. So a little bit simpler. Okay, so lots of people want to know what kind of tax implications. What am I doing? How can I avoid taxes? How can I make sure my loved ones aren't paying taxes? It's pretty, I think it's a pretty healthy and a good outlook, because you don't pay, or your children and your direct descendants, your siblings, your stepchildren do not pay inheritance tax. Inheritance tax is based on the relationship of the decedent to the person inheriting. So if you give to your spouse, 0% inheritance tax. If you're giving to your children, to your siblings, to your stepchildren, no inheritance tax. However, If you're going to give to your friends, your next door neighbor, your niece or nephew, that is a 10% hit for them. However, they are 90% ahead of the time. So ahead of the game, I should say. So, there is a 10% inheritance tax to certain people based on that relationship. And that is what it is. Let's see, federal estate tax is for the pretty wealthy, unless people in this room can convince me otherwise. But 13.99 million in 2025. Anything worth over 13.99. I know you're really close, but so you have to watch it. But if you're under 13.99, don't worry about it. If you're over 13.99, then we need to do some estate planning to avoid that federal estate tax, which is pretty hefty. It can get up to 40% estate tax. So if you are married, the good news is that doubles. So 13.992 times 2 is 27.98. Okay, that's the federal estate tax. Federal exemption sunsets, however, January 1, 2026. However, the mumblings of this administration is that they're not going to let it sunset. So we'll see. If you're worth more than 5 million in Maryland, there is a 16% estate tax in Maryland. There's talk of reducing that exemption amount to 2 million because the state is undergoing this deficit. So they're trying to find some ways. My understanding is that's dead. That is not going through. But anyway, just something to think about. Right now it's 5 million. If you die with more than 5 million, that overage would be taxed at about 16%. And that's it. I mean, taxes aren't that bad. I know a lot of people worry about it, but it's pretty rare that you would have taxes affect. There is capital gains, income tax. There's other things, but these kinds of taxes are pretty manageable. Oh, we got a quiz question. Okay. Drum roll. Okay. What percentage of Americans have a will in place? Yes, sir. 12%. 15. Now, mind you, the other slide said 72% of Americans think that everyone should have a will. So you're saying 36. What do you think? 38. All right. But even 72% say you should have a will in place. You think it's 72% of Americans do have the will in place. I'm just trying to mess with you. I don't know. All right. You guys ready? 33% of Americans have a will in place. Young man, you are the winner. I think that is the point of that. So people believe everyone should have a will, and yet they don't follow through. Thank you. Thank you. Okay. All right. So revocable living trusts are an estate planning document that can be very handy. Sometimes they're overkill, but sometimes they are really very useful. So anything inside a revocable living trust avoids the probate process. I mentioned before, these are private documents. They're not going to go through the probate process, so they're not part of public record. You name a person inside the trust to manage the trust assets in the event you are incapacitated or even if you're deceased. So that person's called a trustee. You are the first trustee. You're the trustee of your revocable living trust. If you become incapacitated or die, you name your spouse, you name whoever. We have a succession of people to stand in your place to be the trustee. If you own property, like you may a beach house in Delaware, if you use a revocable living trust, you avoid probate in Maryland as well as Delaware. So that's where it's very helpful if you've got property in two different jurisdictions. Consolidate them inside a trust and you've avoided 2 probates. If you have an LLC, if you have a small business, revocable living trusts are private. All of that information is not about your business, what it's worth. Everything else is not going to be in public record. So your clients, your employees, your competitors are not going to know about whatever is in that LLC if you have it inside the trust. Married couples can use a revocable living trust to avoid taxes if they're at that very high wealthy level. So there's some nice benefits of a revocable living trust. If you're really wealthy and you want to give away some money so that you're not exposed to taxes, you can give up to $19,000 per year per person, and you don't have to file what's called a gift tax return. So it's kind of interesting. It's the person giving that has to file that gift tax return. The person receiving the gift, no problem. You can just do that, and that's not an issue. You can give unlimited amounts for someone else's medical or tuition needs. You can always give an unlimited amount to your favorite charity. Planned giving, and this is more like for nonprofits, how you can help them over time through your will. Donations to your church, giving gifts on your death. Anyway, we got another quiz question. Okay, you guys ready? What is the number one reason people would say they do not prepare their will? A difficult topic. We got one in the back. They're causing what, please? Fights. They think if they have a will, they'll cause fights. So they don't even want to think about it. They just think there's going to be this controversy and let them deal with that. I'm not going to talk about it. Okay. Anybody else have a good reason that that people don't prepare their wills? Yes. Yes, ma'am. In the blue vest. Yeah. Next to Jackie. Just kind of lazy. Just kind of don't get around to it. Okay. Procrastination. Okay. The cost. Okay. Yeah, that's right. Cost. A little bit intimidated by that. Okay. You think those are our reasons? You're facing your mortality and no one wants to do that. That's a good answer. But you don't need any more glasses. Just kidding. Okay. So let's see what our number one reason is. They don't think they need one. Oh, I don't think anybody said that. Did anybody say anything close to that? I'm sorry. Oh, okay. Well, we'll think of something else. Okay. So many people just feel like, I don't need it. Everybody else needs one, but I don't need one. Okay. So that's kind of that first document we talked about, which is your will. What happens after you're gone? And maybe dovetailing that with a revocable living trust. The second document that everyone should have in their estate plan is called a power of attorney. And a power of attorney would name someone to manage your financial affairs in the event you are mentally incapacitated. The power of attorney dies when you die. A lot of people get confused about that. They'll come into my office and say, but I'm power of attorney and she says she's personal representative. Well, the personal representative is now in charge. So it's the power of attorney while you're incapacitated. Upon your demise, we look at the will. Okay, so this power of attorney can allow for something called Medicaid planning. Medicaid covers nursing home care, and Medicaid is a program for the poor. It gets a little complicated, but that is something that a power of attorney can be used for. If you don't have a power of attorney in place, it's so cheap to do this. If you don't do it and you become incapacitated and someone needs to get access to your bills, someone needs to sell your house, any of those things, now we got to get a guardianship. Guardianship's very expensive, very intrusive. So with a guardianship, the person seeking to get guardianship of you, call it your daughter. So your daughter is trying to petition the court to be a guardian. They get an attorney, but you get an attorney as well. The court appoints an attorney to represent the alleged disabled person. So now you're talking about two lawyers to get your guardianship. And then once the court appoints a guardian, you got to file annual reports It's public record, except it's kind of quiet public record the way adoptions are. So it's not really all the way out there, but I'm just saying it's very intrusive. You've got to keep track, your guardian has to keep track of every penny and account for that to the courthouse. So avoid if you can. And that is with a power of attorney. Very simple document. Your family will thank you. Okay. Next, the third document that everyone should have in place is called an advance directive. This document names someone to make your medical decisions for you if you don't have mental, if you're mentally incapacitated. It also has a section called the living will, which is kind of ironic because it's about how you want to be treated upon your while you're dying. I know this is horrible. It's a very difficult document for people to look through, but you would tell us what kind of treatment you want if you have a terminal illness, for example, and we know that your death is imminent. Do you want to be kept comfortable and allow natural death to occur? Would you like tube feeding? Would you like everything possible? Give it to me. I know it's not going to work, but just do this. So that's called a living will, and that's part of the advance directive. You can indicate if you want to donate organs. You're going to tell us who you want to plan your funeral. You can even say, I've planned my funeral, and here's where the documents are kept. You can tell us if you want to be cremated. So that's the advance directive. Okay, so I think when I asked that previous question about why don't people have wills in place, someone said they don't even know how to get started. So I will tell you. So you can get started just by talking to your spouse if you're married, but if you're single, whatever, just decide who you would want to serve in these various roles. That's half the battle. It's like kind of thinking, who would you want to be the personal representative of your will and a backup person? Who's going to be on your power of attorney and a backup person? Who's going to make your healthcare decisions and a backup person? Sometimes it's the same person all the way through. That's fine, but those are the kinds of things, if you have that in mind when you come into for your consultation, it's very helpful. You would want to have a list of your assets and how they're titled, whether they're in your name, your spouse's name, or both your names. We need to know about your assets. Not necessarily how much they're worth unless you're worth over 5 million. Then we have to talk. You would schedule an appointment with an estate planning attorney. And then once signed, you would keep your documents in a fireproof safe at home, somewhere where we know they'll be safe. Okay, so top 10 recommendations. Number 10, discuss your plans with those who will be involved. So you want to let your family members know, I've named you as my personal representative. Is that okay? It's the polite thing to do, especially on the guardian for your minor children. You want to ask them. Do not just throw your minor children at somebody. So discuss your plans with those who will be involved. Just let them know. I would not give them copies of your documents. Whoops. But I would at least let them know what they kind of in general say and where they're stored. They're in my fireproof safe, in my bedroom closet. The key is in the mug on top of the fridge, that kind of thing. But they're not supposed to look at them. Just keep them there. Don't give them copies, because what happens if you give them copies and you decide to update later? Now you got to say, excuse me, I need that back. And now they know that you're updating. Now they see the history. And so we don't want that. We just want, you get the originals, I get a copy, and that's it. Okay. Number 9, store your will in a safe place. We have talked about that. You can store it at the courthouse if you prefer. I just tell clients, go ahead and just keep it at your home, in your fireproof safe at home. Okay. And then you want to review your will and really all your documents. I say every April 15th because you got to change your batteries in your smoke detector. Just do everything. So you kind of have all of your documents out anyway. You're kind of thinking about the big picture around April 15th. So that's a good time to kind of go through your paperwork and say, wait a minute, we have a falling out, or wait a minute, she moved to California. That's not going to really be convenient. Somebody died, and things happen and you don't realize it actually affects your estate plan because it's just kind of tucked away and you're not thinking that way, which is good. You shouldn't think about dying all the time, but if you just kind of review your documents in April or pick your own date, your birthday, whatever. Let's just, kind of keep in touch and then call your estate planning attorney and say, this kind of changed. Does it affect my estate plan? And, I personally, I don't charge for that. I just let you know, yes or no, whether that makes sense to do another amendment or update things. Number 7, seek advice before adding or subtracting names to titles or otherwise retitling assets. Don't add your family member to the deed to your house without checking first, please. Okay, oops. Number 6, make sure your life insurance is adequate. Check beneficiaries on your life insurance and retirement plans. Your ex-wife should not be the beneficiary on your life insurance, unless that's part of your settlement agreement. I'm just saying, let's make sure those beneficiaries are up to date. Keep some liquid assets in your estate. Your estate planning attorney will help you with that. So we need some cash sometimes to pay for utilities or property taxes. Things happen. Number 4, please choose a capable personal representative, someone that returns the attorney's calls, signs the papers as they're needed to be signed, and, gets things done, sells the house. Let's get moving. Let's get this thing open and closed so that everybody can just get their inheritance and move on. Number 3, plan for inheritance or estate taxes if needed. Number 2, please, I would love it if you kept organized, adequate records. It's a dream. It's always lovely when we have very good tax records and everything else to reconstruct what's going on if we need to. And number 1, please don't write your own estate plan. I know it's tempting. There's lots of stuff on the internet, but that is job security for me, if I can say it that way, because it is a mess when people do that. Because it's very cookie cutter. A lot of them are written for all 50 states, and we are 50 different states. It's not going to be to your benefit. And you're talking about everything you've worked for your life. Why would you cheat yourself on that? If you have minor children, why would you skimp on that? So please don't write your own estate plan. And that's it. This is my information if you need it. If you got a pen, you'll have it that way too. And can I open it for questions? Okay. Does anybody have any questions? Yes, ma'am. Okay, the question is, how does it work if you transfer title on your primary residence into your revocable living trust? Do you get to still deduct the property taxes off of your income tax return? Yes. So during your lifetime, the revocable living trust is running under your social security number. So everything is still you. You just have this kind of veneer. You have this new step where you're now called a trustee. And so it runs under your social security number. Upon your demise, we get a different tax ID number, and it's its own entity at that point. It has its own tax return, and it's irrevocable, meaning we can't put more assets in, we can't take assets out, we can't amend things. We're kind of locked in. Hey, Kathy. If you You go through probate if you own an asset that is in your name only and does not have a beneficiary. So typically when a first spouse dies, no probate, or maybe there's a car, like, maybe one thing. It's typically when the second spouse dies that there would be a probate process. I'm sorry, I didn't repeat your question. Well, okay. So the question is, what obligation do we have to creditors when the first spouse dies? Is that what we're asking? Okay. There's no obligation. We kind of ignore their phone calls, we ignore their texts, their letters. Or some people are like, that's not what my husband would have wanted. I'm going to pay his bills. And that's fine too. You don't have to. That's the thing. You don't have to. If they don't file a claim against the estate within 6 months, they're locked out for good or bad. That's how the law is. Okay. Was there a question in the back? Yes, ma'am. Okay. So the question is, does an estate planning attorney also do tax planning? Yeah, sort of. I call the CPA in when I need to. And I have a friend who actually was a tax attorney with the IRS. So I'll call her if I need some. But just by virtue of being an estate planner, you're going to know tax law too. So I call in the experts when I need them. Yeah. Yes, ma'am. Miss Brandy. Okay, the question is always the question comes up. How much is this going to cost me? Okay, so it really depends. I know you don't like that answer. When we meet at the consultation, I'll have a better idea of what we're doing. I would say for a single person, maybe $1,200 if we're doing all three. Maybe, if you're doing a trust for minor children, that's going to be some work. So if you have a farm and you want it to keep in the family, we've got to do, as I say, it's just you've got to meet with the client and understand what their wishes are. So at the top end, I would say even 5,000, 6,000, depending on what the assets are. Okay, another question? Of course, I'm going to say no to that. So her question was, can we find any of these documents online and just do it on our own? So I would not advise that. But yes, the Maryland power of attorney is online and the advance directive is online. But I really feel like you need an attorney to interpret what you're signing there. Those are some important documents. Let me get someone new. Okay, yes, sir. Okay, the question is, what's the difference between a living will and an advance directive? The living will is actually tucked inside the advance directive. The advance directive is three parts. The first part is who's going to make my healthcare decisions while I'm living. The second part is what's the treatment do I want? What kind of treatment do I want while I'm dying? And the third is what happens after I die? Do I donate organs? Who's going to plan my funeral? So it's while I'm living, while I'm dying, and after I'm gone. That's the advance directive. That middle section, while I'm dying, is called a living will. Okay. Long answer, sorry. Okay, I think you had a question, didn't you, sir? Okay, so the question is, what if you prepare your documents in Maryland and then you move out of state? You would want to have a local attorney in that new jurisdiction review the documents. I do it all the time. Sometimes someone comes from wherever, and it's a few tweaks and now it's in conformity with Maryland law, or sometimes we just have to start all over. So it's kind of interesting. The 13 colonies kind of thing it still flows through. Like the 13 colony states kind of have the same kinds of laws, whereas Louisiana is more of a French influence and out west it's more Spanish. So if you stay on the East Coast, you might be all right, if that helps you. Yes, ma'am. Hmm. Depends on how you want to title things. So husband and wife, are we talking? Okay, two sisters own two different houses. Can they give it to the same person in two different trusts? Yes, you can do that. One trust, yeah, you could do that. So I'm sorry for those not in attendance. So the question is, can you consolidate? Can you have one trust that gives to one beneficiary? That's what a person who inherits under a trust is called, a beneficiary. So those two people can give into that trust. Two different people that aren't married can give to that beneficiary in their trust. Yes, ma'am. Okay, so the question is, as a trustee of a revocable living trust, while you are living, you are the trustee of your own trust, and you have your house or whatever property inside the trust. Can you still sell it? Can you put a mortgage on it? Yes, you have total control. You're still in total control as a trustee. Yeah. Yes, ma'am. Okay. Do I need to repeat that question or does that count when you call, when you talk? I can. Okay. So the question is, if you have a revocable living trust in place, what are the costs annually and or what are the costs to amend the trust? Is that right? Okay. So annually, basically, it's nothing. I mean, there isn't a separate tax return for the revocable living trust because it's under your social number. So you're still just, you have this title called trustee, but it's really kind of invisible. So there's not really an annual cost. But if you amend the trust, yes, there's a legal fee to update your trust if you need to. And I usually just do that on an hourly basis because I don't even know what it's cheaper for the client to do it that way. Okay, yeah, thank you. Any other? Yes, ma'am, in the back. Okay. Okay, so the question is, if you own property in two different jurisdictions, are you going to need two different attorneys to prepare your documents? So your documents are going to be prepared where you live. So if you're a Maryland resident, you would have Maryland documents put in place. But if you need to transfer that property that you own in DC into the trust, or if you own a beach house in Delaware and we need to transfer it into the trust, you have to get a local attorney there to do that. Or in Maryland, there are lots of attorneys who are licensed in both DC and Maryland. You could work it out maybe, but typically, if it's a beach, whatever, you do have to find someone that can transfer that deed into the trust if it's outside of Maryland. Anybody else? Okay. I think that's it, right? Okay. Thank you. Yes. Thank you. Thank you very much. Yep. Certainly call or email if you have any other questions. And if anybody wants a pen or pad of paper, we got that up here too. And candy on the back table. Right. And what information that's or did you want to? Event is April 30th. It is. Oh. Did you want to see a picture? I don't know how to. If you can figure out the picture. What is your name so I can tell?